Hello, and welcome to the Free American Voice podcast from Midwestern Citizen. Today's episode will be part 2 of 2 on our COVID series. We'll be discussing some of the legal measures being taken to counteract the spread of the virus. My name is Raj Ashar. I'm a senior at the University of Michigan, majoring in economics, and I'm also a senior editor at Midwestern Citizen.
Hi, everyone. My name is George Sdregas. I am a junior at The Ohio State University studying philosophy, politics, and economics, and I am a staff writer at the Midwestern Citizen.
Hey, everybody. I'm Jason Siegelin. I'm a senior at the University of Michigan studying economics, and I'm the editor-in-chief of Midwestern Citizen.
My name is Paul Odu. I'm a senior studying economics and constitutional democracy at the University of Missouri, and I'm an associate editor at the Midwestern Citizen.
Awesome. So to start off, we've recently seen the Omicron variant in the news, and some of the kind of measures that we're seeing taken with it are the rise of kind of a third booster dose of the COVID vaccine being required at some universities. So at the university I attend, University of Michigan, recently announced the requirement of this third dose of the vaccine, which also then asks the question, what does it mean to be fully vaccinated? And I think we're also kind of seeing a lot with employers requiring the vaccine, and in terms of some statistics on vaccine requirements. A lot of people who are unvaccinated would consider leaving their job if their workplace required a vaccine. A recent survey said 75% would consider it. But then on the flip side, you also do see some people wanting that vaccine requirement in the workplace and actually would consider leaving if there was not a vaccine requirement. And so that statistics from the same survey said 40% would consider leaving. So I think this presents kind of an interesting environment. And Jason, do you want to talk a little bit more about what we're seeing with the legal landscape around these vaccine mandates?
Absolutely. And just going back on your one of your previous remarks, I think that the disagreement between employees who want more protections against these different variants and the employees who want perhaps maybe less protections and are making liberty arguments, this dichotomy really is reflected in the courts and in jurisprudence. And really, there's really two trends that I want to highlight. I'm not a lawyer, but I have looked through these cases and these decisions. There are really two trends that I do want to highlight, as mentioned. The first is the existence of religious exemptions in these vaccine mandates. Particularly a really recent case that was on the shadow docket was We the Patriots USA versus Kathy Hochul, the governor of New York. And this was a case that involved a New York vaccine mandate for healthcare workers. There was no religious exemption for this vaccine mandate, but there was a medical exemption. And the plaintiff brought a claim against the court, again, not against the court, but against the governor, based on this absence of religious exemption, because all of the plaintiffs were practicing, I believe they were all practicing Christians. And they were against the idea of the use of aborted fetus cells, so aborted fetal cells in these cell lines that were being used to develop these vaccines. They were all opposed to that on the grounds of their religion, but nonetheless, and they were all healthcare workers as well. I think most of them were nurses, and the state did not have an exemption for them. So they were subsequently at risk of losing their jobs. So this really goes in line. It's actually surprising considering the more conservative lean of the court, and it really, this sort of religious exemption jurisprudence goes in line with a lot of stuff that the Roberts Court has ruled on in recent years regarding COVID. There's been, specifically Roman Catholic Diocese versus Cuomo. That was a New York case, but that was at the Supreme Court level. And there's also a case called Tannen versus Newsom, both of which the court sided in favor of the plaintiffs who were complaining against the restrictions on the supposed restrictions on their religious freedom brought about by vaccine mandates, and also restrictions on the ability to attend church service. And this really goes in line with what's called the most favored nations, most favored nation analysis of certain religious issues that is popular in the Roberts Court. And I think just going back to the case at hand, We the Patriots USA versus Hochul, Gorsuch's dissent from the court's decision to effectively not hear this case really highlights the desire for strike down these vaccine mandates based on the lack of religious exemptions. Particularly, Gorsuch highlights the fact that although there was a medical exemption, there was no religious exemption. So in his dissent, Gorsuch highlighted that there was intent behind this the absence of religious exemption, particularly the governor's statements regarding these religious dissenters was sort of expressive of that intent. But the main thing was that, citing Fulton versus Philadelphia, Gorsuch highlighted the fact that there was no comparable exemption for religious dissenters, but there was an exemption for medical people who could not take the vaccine on medical grounds. So this is a trend that we've seen, as I mentioned, Tandon versus Newsom, Roman Catholic Diocese versus Cuomo, in other cases like that, where we see that Gorsuch's dissent is in line with those cases in the most favored nations analysis as well. Another case that really highlights another trend that I want to mention is the Sixth Circuit's ruling in the OSHA vaccine mandate for employers with 100 or more employees. Now, this is a case that relies heavily on the definitions of various terms in the OSH Act, particularly that authorize this use of the police power. Particularly, one term is the term grave danger. And the litigants were really arguing over what does this term mean? And so specifically, the OSH Act says that in cases of a grave danger, the OSHA may take certain regulatory actions. One of these regulatory actions may be a vaccine mandate for workers. And so the definition of grave danger is interpreted differently by the Sixth Circuit and the Fifth Circuit. Particularly the Fifth Circuit interprets this term way more leniently, saying that COVID is not necessarily a grave danger, whereas the Sixth Circuit interprets it a lot more stringently, saying that COVID is definitely a grave danger presented to employees. So there's definitely also a lot of subjectivity in this analysis. And so in these gray areas of the law that we're seeing, particularly in which court cases are decided upon definitions of specific terms, we're seeing a lot of political preference taking the place of a more objective analysis of these issues. As we know, the Fifth Circuit is a lot more conservative, and so we see maybe a more politically influenced decision there, whereas the Sixth Circuit is a little bit less conservative, and we see maybe perhaps a differently influenced decision there in determining how these judges define the term grave danger. So these are some trends. Number one, as I mentioned, the fact that religious exemptions or the failure to add a religious exemption for a vaccine mandate is prompting litigation. And the second trend is really the subjectivity that we're seeing, which is the analysis is being substituted with more political preferences.
Yeah, there's a lot of ground to cover there, but I think talking about the idea of religious exemption, it's really important to see how society views them. And this is something that UC Hastings law professor Dort Rice is marked on. And it's the idea that religious exemptions are being used as a matter of political identity. And I believe one of the reasons this is viewed in this way is that besides for a medical exemption, there's no other exemption from the vaccine that's really been seen as mainstream. It's obvious that vaccination has become a political topic in our country. I've been in arguments about vaccination with people. I've heard arguments between people seen it all over social media about whether to get vaccinated or not, whether you should have to, whether it should be mandated. So oftentimes I think religious exemptions are going to be the only avenue in which people could express their political identity. And that really isn't the use of the religious exemption. It's very important that it's very important to distinguish that because you believe something politically does not mean it should be used for religion. Something to compare it to was during the draft in Vietnam, and there was the conscientious objector status that was given to people. It was only given to people that could prove that they shared this belief that they were like against war for like their entire lives. And this is a standard that could very likely be implemented one day in regards to vaccine mandates. Like if you have every other vaccination in the book and then go in front of a court of law and try to claim that you're against vaccination, it's going to be really hard to prove when you've received other vaccines. And it's going to be really hard to show that this isn't trying to fill a political agenda, because the distinction between political beliefs and religious beliefs, it comes down to like constitutionality, really. Like religious freedom is a First Amendment constitutional right. And when political identity is being brought in and trying to be used through that avenue, it really threatens it for the American people.
Interesting point you make. Yeah, you can even see it in the military. I mean, thousands of service members have sort of refused to get the COVID-19 vaccine, citing religious exemptions, and they aren't having a lot of success in the military. So it's sort of interesting to see that sort of dichotomy between civilian life and military life, whereas the connection between politics and sort of vaccine mandates has for sure become blurred, but how sort of military justice views that and how politics is sort of used to sort of justify religious exemptions. I think it's something that requires a lot more sort of exploration, and it would be nice to, have the Supreme Court bring some clarity or bring some semblance of, uniformity to religious exemptions and vaccine mandates, so that there's a lot less sort of regional discrepancies that are, quite frankly, making a lot of people frustrated.
Yeah, I think going off of that as well, just the striving for this uniformity in jurisprudence regarding mandates and regarding these sort of communal initiatives. This really, and I think maybe George or Paul mentioned this as well, but this brings a lot of parallels to Vietnam and the sort of what George was talking about, conscientious objectors, and really, there's really back then too. There really didn't seem to be much consistency in judicial opinion regarding what the extent to which somebody could claim to be a conscientious objector, and even when there was consensus regarding that, there really didn't seem to be too much regard to the limits of at which a conscientious objector could be going his or her own way and disobeying the sort of the desire for the government to coerce them into service. So that's an interesting concept there. And I just wanted to bring up a statistic as well. There have been in the case We the Patriots USA versus Hochul in the state of New York, I believe, looking through my notes here, there were 1,400 employees in Northwell Health, which is a hospital system in the state of New York, that were terminated for refusing to accept the vaccine. That's a lot of people, especially when you're considering a regional health system like Northwell. So it's a really interesting sort of dynamic as well that links to the economic realm in that in the discussion we were having last time, which is really, what are the economic prices we're willing to pay? What's the cost benefit analysis we're doing here? And as I mentioned with the whole conscientious objector jurisprudence, there doesn't seem to be a clear weighing mechanism through which we can weigh the costs and benefits here. So, and I think We the Patriots, the case in New York, really brings that sort of analysis to play.
Yeah, that's fascinating. I think that just generally with COVID-19, when you're looking at either vaccine mandates or the economic or political ramifications, I think it really boils down to just ad hoc policy, because the shock was so sudden, so unprecedented, and the United States didn't really have sort of a strong public health infrastructure to address this at the onset of the pandemic last year. I think that it really comes down to having consistency in policy, and it comes down to making sure that individual political rights aren't being sacrificed at the expense of economic or public health goals, while ensuring that individuals are remaining safe and ensuring that we can bring an end to this pandemic as soon as possible. And I think that ad hoc enforcement has become even more sort of dire, given that there's not a lot of clarity on the effects of new variants. There's not a lot of clarity on, what sort of regions are most susceptible to new infections, least vaccinated regions, I should say. And there's not real clarity on sort of the path forward with respect to ending the pandemic. It seems like every other week there's a new variant that is either more contagious or more deadly. And I think that the fact that we're in the pandemic and we didn't sort of have a strong sort of public health plan before the pandemic really just makes it even harder, because we're having to learn by experience. And I think that ad hoc enforcement is something that, the higher courts, higher federal courts are going to have to deal with. And it's concerning, because I'm not sure that they have the expertise to actually, make good decisions here. I mean, being a judge requires knowledge of the law, but it also requires knowledge of technology. It requires knowledge of public health. It requires knowledge of society and economics and factors that go far beyond sort of legal doctrines and legal dogma. So yeah, it'll be really fascinating to see how these vaccine mandates hold up in court and what the future of sort of public health enforcement looks like in the United States.
I think something impeding the court's ability to make decisions, and by courts, I mean plural courts, just the circuit courts, district courts, and the Supreme Court, maybe impeding or facilitating, is the precedent established in Jacobson versus Massachusetts, which upheld a vaccine mandate. And a lot of individuals, a lot of lawyers, a lot of judges are citing Jacobson as a way through which to uphold many vaccine mandates. It's been cited countless times, and really any of these cases is at play. It was really the first case heard at the Supreme Court level that dealt with a vaccine mandate. And so it's kind of like, it kind of feels to me that Jacobson is sort of, at least for conservatives, it's impeding progress in sort of taking a more nuanced approach to vaccine mandates. And for more liberal judges, it is more of a facilitator. But nonetheless, it calls into question such an old precedent that, according to Gorsuch, in his concurrence with Roman Catholic Diocese of Brooklyn versus Cuomo, it failed to consider the claim in Jacobson was not a First Amendment claim. It was not whoever I forget his first name, but Jacobson was not challenging the vaccine mandate on First Amendment grounds. And so this kind of leaves some space for some plaintiffs, in Gorsuch's opinion, at least in his concurrence in Cuomo. It leaves some room for plaintiffs to bring claims on First Amendment grounds, in that, according to some, Jacobson has been effectively overruled by Cuomo and some other cases as well. So it in the First Amendment sort of sphere, and so it leaves a lot of room for jurisprudence regarding the First Amendment and vaccine mandates, especially when we have the case that I mentioned earlier, the absence of religious exemptions. So there's definitely some nuance that is slowly being injected into this interpretation of Jacobson versus Massachusetts. And like we've seen in really any precedent that's been struck down, whether it's Plessy versus Ferguson or any other case that used to hold precedent but then was reversed, we may see a reversal in the interpretation of Jacobson versus Massachusetts, depending on the conservative or liberal composition of these courts.
Yeah, I think that Jacobson case and the precedent in general, when it comes to like mandates regarding public health, is like murky to say the least. And I think a lot of that has to do with like technological advances we've made, especially in recent years. Like logically, if COVID was happening 100 or 200 years ago, I don't think vaccines would even be out yet. Just technologically speaking, we're in a way different spot in society. And I think it really like embarks on your like your opinion, Jason, that like new precedent needs to be set for this, especially given the fact that it doesn't address like First Amendment issues. And like as we said before, the idea that like now like the First Amendment, religious freedom is being used to like show political identity and value political beliefs, something that this precedent obviously wasn't accounting for. It looks like by the end of this pandemic, we'll have some new precedents set on like really where to draw the bright line of where we can mandate things in order to value public health, and like where like individual rights come into play. So that bright line is really yet to be drawn, in my opinion.
I think it's also important to note that like when these cases are decided, a lot I think has to do with like the current environment of the virus that's kind of progressing at the time. Because I think what Jason mentioned, I think with the OSHA case was talking about like the term grave danger and how that can mean different things. And I think with COVID, we've kind of seen it ebb and flow, where at some points it might be a grave danger, just because in a certain region, hospitalizations and deaths are super high. But then at sometimes maybe it's not. And I think also with the technological development too, that's going to add an interesting wrinkle to things. Because I mean, right now there's development of treatments. Merck has a pill, Pfizer has a pill. And if these turn out to be successful, maybe vaccine mandates will go away, or they might stay in place with a number of exemptions, since I mean the alternative to not getting vaccinated isn't that bad, since you can always just get a potentially effective treatment.
Which calls into question from a legal standpoint, are these vaccine mandates, if we have the option to take a pill that may treat the disease but doesn't necessarily completely eradicate it from the human body or whatever, are these regulations, is the OSHA regulation, for example, is that narrowly tailored enough? If we have alternatives, if you can force employees to take the new pill, or you can force employees to perhaps social distance, are these regulations, are these strict vaccine mandates, especially for the healthcare workers, many of which don't include a weekly testing option, the court the introduction of these pills or these different solutions to the virus, as well as geographic disparities, may call into question whether or not these regulations are actually narrowly tailored. At least especially in First Amendment cases where we see strict scrutiny employed, that's definitely a question.
Yeah, I also think it begs the question, if that were to be the world we're living in, where like pills and effective treatments are created, is mandating in general the best route to take? I know beginning in my home state, Ohio, incentives were what was the main avenue through which they were trying to get people vaccinated. There was an Ohio vaccine lottery where once a week they were picking a winner to get $1 million. Just if you got vaccinated, you were automatically entered into the lottery. There were employers offering pay raises. Maybe it's more efficient for hospitals to say increase the wages of their workers if they get vaccinated versus not, than trying to mandate it and really avoiding all the individual rights issues as a whole.
That's really interesting, George, because there's studies that have come out that showed that those incentive programs for vaccines actually weren't all that effective. So if we're seeing a situation hypothetically where mandates aren't effective and providing incentives, whether that be cash, prizes, et cetera, for vaccines are also ineffective, it really comes into question. It really brings into question whether the government actually has effective mechanisms to bring an end to the pandemic through the proliferation of vaccines. And it's something that's, I think, even transcends sort of legality. It transcends what happens in the courts. It's really based on sort of a coordination between effective technology, actually getting treatments out to the public, political will, whether these sort of mandates will actually be even politically viable given current divisions in Congress with the further mandates, especially once the guidance is sort of given by the courts. And I think that really it just comes down to individuals. And just like you were saying with the religious argument, that sort of blending of religious belief and politics, I think that all those factors sort of create a very, very difficult situation. Even with the pills that we've been talking about, I mean, I imagine there's going to be coordinate pushback against those, just like there is with vaccines. So it's a really complicated situation. And if incentives and mandates don't work, it's kind of hard to see how the government can sort of push for, greater vaccine usage, and more philosophically, whether that should sort of be the main avenue for actually ending the COVID-19 pandemic, if there is potentially another way to sort of drive down infection rates. I know Jason was talking about maybe having social distancing measures back in place, but then we get back to the question of whether a lockdown again is viable economically. So there's a lot of challenges there, and I think that analyzing the legal argument is super, super fascinating, just because of the lack of sort of regularity and uniformity in enforcement.
And I think a lot of the reason that the U.S. kind of went to these mandates is a lot of it is trust in government. I think countries, we've seen, like looking globally, countries with high levels of trust in government, such as Sweden and Norway, they tend to have a higher vaccination rate without having to resort to vaccine mandates. And I think it's also possible that using incentive programs and maybe using mandates potentially reduces trust among the population. I mean, people generally don't like being told what to do, and I think the government trying to do that potentially reduces the trust in the population, which could potentially also, for just down the line, hurt any other measures that they try to take.
Yeah, that's a really good point, Raj. Like, say the vaccine mandate is only like the mandate of the first 2 shots of like a Pfizer or a Moderna, and the trust is really shot within the country. And then now all of a sudden it's booster time, and this booster is like proven to be rather essential to slowing the spread of the virus. And there's just a complete lack of government trust. People aren't going to go get it, almost out of spite for the government, maybe. And they're going to have a really hard time implementing like a mechanism in which people could receive that booster shot. So it's important to look at the fight as like something ongoing, that like the actions of the government now are going to have consequences for future action that they could take to help stop the spread.
Yeah, I can only think of a couple events last year that decreased faith and confidence in the government. It's a really, really heady time right now. And just like you were saying, George, I think that any action taken to sort of mandate or influence, individuals' decisions to get a vaccine is going to cost, future political will. And it's really going to require a calculation of whether that's worth it, or whether there's another alternative to make sure that the government has the sort of public support it needs to actually implement future, not just programs related to COVID-19, but programs related to future crises that we're undoubtedly going to face, related to climate change, economic inequality, racial justice. A lot of the reckonings that we saw last year, I think last year was sort of a microcosm of a lot of the problems that the United States and the globe are going to face in the coming years. So yeah, it'll be really interesting to see how this pans out.
And speaking of this sort of legitimacy, the lack thereof that the government has, maybe in a lot of the eyes and a lot of Americans' point of view, is this sort of, and this is maybe not necessarily the executive branch and the legislative branch, but talking about judicial legitimacy. And I want to talk about the Sixth Circuit's reinstating of the OSHA vaccine mandate for employers with 100 employees and up. Particularly the analysis the Sixth Circuit employed relied upon the Commerce Clause. The OSH Act, which effectively authorized this mandate to occur, also relied upon the Commerce Clause. And specifically, the Sixth Circuit mentioned mentioned that the illnesses arising out of work situations impose a substantial burden upon interstate commerce, and I quote that from their decision. And so you wind up with a lot of these cases under the Commerce Clause that through which government power over the last century and today, as we see through these mandates, is expanded under this very, very contested, very, very malleable part of the Constitution. Just read through Rickard versus Filburn in the 40s. That was a case under the Commerce Clause that was a real example of the extent to which the government may go in arguing its case under the Commerce Clause and supporting and justifying its expansion of its authority. And so I wanted to open that dimension to it as well in terms of how legitimate is the judiciary going to be seen if it continues to use these Commerce Clause arguments. It seems to me that the Sixth Circuit used it without necessarily acknowledging its contestability, which is somewhat concerning. At the same time, you can use it. It's part of the Constitution, which is somewhat concerning from a legitimacy standpoint.
That's a great point, Jason. I think I mentioned in my First Amendment and technology article talking about big tech platforms that it's really, really important to consider whether old legal doctrines can actually be adequately applied to new circumstances. And I think that COVID is a prime example of that. Should we allow judicial authorities to sort of bend and mend the Constitution to meet the current circumstances? Should we have something that's a lot more stable and sort of a law that's actually adequately promulgated so people know what the law is and how to sort of act within the confines of it, rather than sort of this ad hoc process of X happens and everything changes, and then 2 weeks later Y happens and then everything changes again?
And from the partisan standpoint as well, from between the Fifth Circuit and the Sixth Circuit, there's clearly would be a divergence in the interpretation of the Commerce Clause. For, as I mentioned earlier, when you have these gray areas in the law, when you have cases being decided upon the definition of what a grave danger is, these subjectivities really leave a lot of space for partisanship, leave a lot of space for political biases. And I can't help but think that the Commerce Clause is subject to that as well, as we've definitely seen in the past. So it's interesting how the Commerce Clause seems to have almost infected every realm of jurisprudence, including up to the past few days. So it's definitely plays a really important role. And so as we're seeing, as a result of this, these conflicting, perhaps partisan-fueled disputes regarding whether or not regarding the definition of various terms, regarding the Commerce Clause, regarding the efficacy of mandates, etc. We're also seeing a lot of emergency requests regarding various vaccine policies in the workplace and for healthcare workers. As mentioned before, there's a lot of contestability in this area. There's a lot of cases unfolding as we speak. But nonetheless, there's been a lot of requests for the Supreme Court to opine on these issues. And so with other issues like abortion, with gun rights, and now with mandates, we're seeing the Supreme Court play an increasingly, at least potentially, interventionist role in this case. And we've also just been increasingly seeing the stalemate that this generates and the necessity for a final arbiter to play a role here. Without the Supreme Court, we would really be at an utter stalemate in which different states would have different policies, which is true, but that would be exacerbated without the role of the final arbiter. And so we see these a lot of these requests are occurring. I'm not going to cite any of these specific ones, but there is a SCOTUS blog article that was published on December 18th that cites a lot of them on the emergency docket. And so it just calls into the spotlight the role that the Supreme Court plays and is increasingly playing in American public life, where we have a decreased emphasis on the state courts, a decreased emphasis on state statutes. We have an increased emphasis on the opinion of just a few justices at the top, which may call into question how democratic is our governing institutions at this point, when we have all of these contentious issues being decided at the top level, at the highest, by the final arbiter, as I mentioned earlier. And number one, I think it calls into question a potential impossibility of reconciling these two sides anymore. But I also think number two, it calls into question federalism at its core. How much of a sort of how are powers divided? To what degree are powers divided between the federal government and the state governments when we have essentially all of these state level initiatives being effectively brought up to the highest court in the nation? I think with this trend, we're going to see a much more weight being placed at the federal level and a lot less determined at the state level.
Yeah, I think that's a really interesting point you make there, Jason. And I think it's even beyond COVID. I think we're just kind of seeing, like, anytime there's a big ruling that's controversial, it's just kind of assumed that the Supreme Court is later either going to overturn it or uphold it. And so I think it brings less importance to these lower court rulings, as they're always kind of viewed as a temporary thing that's going to happen for a few months, and then the court's going to really decide on it later on.
Yeah, I think honestly, it's also calls into question too, what I would call like the judicialization of politics. Really, when we see this rise in public interest law firms that are explicitly conservative or explicitly liberal, it calls into question the degree to which politics and partisanship has infected the judicial system and has used the judicial system as merely an extension of a partisan effort. And so I think that's an important thing to consider as well.
Yeah, especially given the composition of the court right now with its conservative majority and the fact that conservatives control a majority of the state legislatures. It's really, really interesting to see just how much of sort of judicial policymaking, sort of public policy has been captured by the Supreme Court and has been captured by particular sort of private interests and public interest law firms. And like you were saying, like, if we can't be confident that our democratic institutions are actually going to, one, protect the rights of the people, but also two, protect the intentions of the people. When the people vote at the ballot box, when the people, sort of have strong opinions on a certain policy direction, whether that's going to be either upheld or subverted by the court, that level of uncertainty really tugs at the cords that sort of bring society together, and it weighs upon sort of the future direction of the country and the country's political stability. I think it's a really dangerous moment we're living in now, but it sort of calls for a reset or a reinterpretation of sort of the role of government, the role of the courts, and their role in sort of preserving democracy, and whether it's going to take, something more targeted or a more concerted effort to sort of protect democratic institutions, but also to protect the rule of law.
I think that's a great place to end our discussion today. Thanks to Jason, Paul, and George for participating in this conversation on COVID, covering both kind of the economic effects and some of the legal landscape that we're seeing. Be sure to check MidwesternCitizen.com for our recent December 15th release, as well as our early January release. And thank you for listening, and be sure to subscribe to the podcast.